am an attorney and the owner and managing partner of Family Matters Law Group located in Plantation, Florida. And we cover cases all over South Florida that are contested, and we cover cases throughout the state that are uncontested or are name changes. And I am going to talk about today modifications. So in Florida, there are certain things that are modifiable and other things that are not modifiable. So child support and parenting issues are always modifiable. Now, always, I should say, is a little bit of a tricky word, because these parenting plans and child support are things that have the ability to be modified always, but there are certain requirements that a person has to meet in order to be able to modify. So you can kind of think of this like a hurdle that you have to jump over before you get to the actual modification. And that hurdle is that you have to first prove that there has been a material, substantial, unanticipated, and permanent change in circumstances before you get to the point where we start asking whether or not a modification is in the best interest of a child. So we first have to prove, and therefore we have to assess as attorneys whether you meet that first requirement. So every single word that I said is important in making that determination. Material, meaning it has to be something big. Something big has to have happened between the time of the last order or agreement and today in order for us to modify the original parenting plan. Material as well as permanent. What happened, whatever that change was, it has to be permanent. It can't be that someone is on temporary unemployment for 2 weeks or has, done something that's lasted for 3 weeks. It has to be a permanent change. Material, unanticipated. It cannot be something that you knew at the time that you entered into the last parenting plan or that the court entered the last parenting plan that you knew was going to happen. One really good example of this is that the child got older. People call me all the time and say, well, I want to change my parenting plan because at the time that the parenting plan was entered, my child was 5 and now my child's 12 and the circumstances are much different. The child getting older alone is not going to amount to a substantial unanticipated material change in circumstance that would warrant a modification because we knew the child was going to get older at the time that that parenting plan was entered into. So material, unanticipated, permanent, substantial, meaning it has to be big. So material and substantial, kind of one and the same thing. Material meaning that it really impacts the child in some way. Sometimes there can be a really big substantial change, but it doesn't overly impact the child. So it has to impact the child and it has to be something big. So if you're contemplating if you're contemplating a modification, before you get on a phone call for a consultation, like my office provides free consultations for people if they're considering these kinds of things, you need to be thinking in your head, what has happened since the time of the last order or the time of the last agreement that has changed and made things different. I'll give you some good examples of things that are a substantial material change in circumstance. That one parent has failed to use a lot of their time sharing for 7, 8, 10 months, a year, 2 years, something like that. That there is a new dependency investigation where one parent has been accused of abusing, abandoning, or neglecting the child in some way since the time of the last order. That the new parent is married to a new person and living with a new person who has some kind of violent criminal record. That your work schedule has drastically changed and that your ability to parent because of that is very different than it was at the time of the last order or agreement. So those are some examples. So you can always modify a parenting plan. You can always modify child support, but you have to show that there's been that material change in circumstance. When it comes to child support, the material change in circumstance is that one parent's income has gone up or the other parent's income has gone down, or that child care costs have changed, or health insurance costs have changed, and that when you take into consideration this new information, your child support number is going to differ by at least $50, somewhere around that number. So that is what the law says about what is the requirement in order to get us to a modification. Now, once we know we can modify, When it comes to a parenting plan, then our next question is what's going to be in the best interest of the child. But we don't get there until we first prove that underlying hurdle. Hopefully this clears some stuff up about modifications. If you have questions or you feel like you're interested in a modification and would like a consultation, you're welcome to get in touch with our firm.